The Indian Contract Act 1872 is the key act regulating Indian contract law. The act, as enacted originally, had 266 sections. Now, if we look at the present scenario, section 1 to 75 deals with the general principles of law of contract. Sections 124 to 238 deals with special contracts such as indemnity, guarantee, bailment, pledge and agency. Further, sections 76 to 123 and sections 239 to 266 have been repealed, and thus the provisions of both sales of goods and partnership have been removed from the Indian Contract Act. Hello everyone, I am Apurva and you are watching Legal Bites. In this video, my topic of discussion is Introduction and Nature of Indian Contract Act 1872. The main objective is to make you understand how Indian contract came into existence, what are the general principles related to the law of contract, and lastly, the foremost explanation of contract pertaining to the Indian Contract Act 1872. I suggest you to please refer the book of Avtar Singh or Principles of Law of Contract by Salmon for comprehensive knowledge. Moving ahead, the Indian Contract Act 1872 provides the legal framework for the formulation of trade, business, commercial relation and transactions in which contract is involved. The Indian Contract Act was drafted originally by the Third Indian Law Commission in 1861 in England. The Indian Contract Bill tried to define laws related to contracts, sale of movable properties, indemnity, guarantee, agency, partnership and bailment. Now covering the scope of the bill was to bring the Indian Contract Act in consonance with the English law on the same subject as established by the recognized practice, statute and judicial decisions. Remember that the bill was not the complete law of contract, but the aim of the bill was to suffice the need of the country for a considerable period of time, because what happened during that time, judges of the courts used to take help from the English laws in determining the case. When they failed to arrive at the judgments by considering the three basic principles, which I hope you all must be aware of: justice, equity and good conscience. And thereafter it was decided that even if some deficiency is found in the bill, it could be added as new chapters. So the bill was drafted to concise the law of contract to suit the needs of the people. Though the drafters tried their best to imbibe the regular practices which were followed in India, but failed to do so. And this we can understand from a particular instance where dispute regarding the peculiarities of the contract arose, and the Indian courts at that time refused to take into account the English law in deciding the case, but rather they took help from the broader and safer law in determining the case, where the usual principle was that whatever man promises, he must do it. But this was not included in the bill. And finally, the Indian Contract Act came into effect on 1st September 1872. Please jot down the date of enforcement, as being law students it's very essential to remember. And through amendments, sections 76 to 123 and sections 239 to 266 got repealed, with separate enactments as Sales of Goods Act 1930 and Indian Partnership Act 1932. Please don't forget to refer bare Act of Indian Contract Act, Indian Partnership Act, Sales of Goods Act, either separately or in a combined form. That's completely your choice. Moving ahead with the general principles of the Indian Contract Act. We know that the contract is the most usual method of defining the give and take rights and duties in a business transaction. This branch of private law is different from the other branches of law in a very important respect. I hope you must be aware of private law. Private law is a law that deals with relation between individuals. Now, parties to a contract are the makers of law for themselves. They can frame any rules they desire to the subject matter of the agreement. And this is the most important point, that law takes cognizance of their decision unless they are not legally prohibited. ahead with the Section 2H of the Indian Contract Act. In the language of Bare Act, Section 2H defines as an agreement enforceable by law is a contract. When we explicit this definition, we get two essential components. Firstly, an agreement, and secondly, enforceability by law. Section 2E of the Indian Contract Act defines agreement. In plain language, we can understand agreement as a result of the proposal made by the one party to the other party, and here the other party gives his acceptance thereto. Now the question arises, when an agreement becomes contract? Enforceability by law indicates an agreement becomes contract when it gives rise to legal obligation, meaning thereby a duty enforceable by law. Thus we can say that law of contract deals with only such legal obligation which have resulted from agreements. Here we come to the end of the discussion of this topic and will soon come up with the next video. This is just an introductory video. Till then, keep studying and keep watching Legal Bites. Follow Legal Bites for getting subject-wise knowledge on all legal topics, mock practice series for judiciary and much more. Please don't forget to like, share and subscribe the video. Thank you for your attention.